Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Imagine you find yourself in this incredibly vulnerable position. You're at work. You experience something that just totally crosses the line. I mean, clear, documented racial harassment. And you do exactly what you're supposed to do.
Right, you follow the employee handbook.
Exactly. You report it to your manager. You escalate it to HR. You expect the system to correct itself, right?
Yeah, but instead of a resolution, you suddenly notice your schedule has been completely rearranged.
Yes. The shift you've worked for years is just gone, making it impossible to get to your college classes.
Yeah.
And you're suddenly cut out of crucial safety emails.
It's nothing dramatic like a firing, just 1,000 tiny administrative cuts that make your day-to-day life unlivable.
It's so insidious.
It really is. It's a profoundly isolating experience, and it's a pattern that plays out in workplaces far more often than people realize. I mean, the initial harassment is traumatic, but the subtle bureaucratic squeeze that follows, that's what actually forces most people out the door.
And when you try to fight that squeeze in federal court, you're usually met with this incredibly rigid, almost impenetrable fortress.
Oh, absolutely. The legal system expects you to have the secret passwords, the exact formatting, the nuanced legal jargon.
Right. One procedural misstep, one missed deadline, and those massive iron gates just slam shut.
The federal court system is, well, it's terrifyingly unforgiving if you're trying to navigate it without a law degree. It's designed around an adversarial process that assumes both sides have equal access to high-level legal representation.
Which is why we are looking at a legal landscape today that is genuinely inspiring. We are unpacking the story of a lone employee who took on a massive corporate machine and actually won.
It's a remarkable story.
So to give you the exact context for our deep dive today, Mark Carey included this case as it represents a significant win for a pro se plaintiff, Sierra Hawkins, in her racial discrimination case against Federal Express. Hawkins filed her own complaint and was able to reach a settlement for an undisclosed amount on February 4th, 2026, and the case was closed.
A huge victory.
Yeah. Sierra Hawkins represents the type of courage and strength all employees should live up to when addressing an employer's illegal behavior.
Definitely. And the paper trail that got us to that February settlement is just a masterclass in perseverance.
So what are we actually looking at today?
Well, to really unpack the mechanics of how she dismantled that corporate defense, we're analyzing two primary documents. First, we have a pivotal October 2025 court order from U.S. District Judge Miranda M.
Which completely altered the trajectory of the case.
It did. And second, we're looking at the official December 2025 legal answer filed by FedEx's heavyweight defense attorneys.
Okay, let's start by setting the scene based on the factual background drawn from these filings. Because to understand the magnitude of taking down a giant like FedEx, you have to understand exactly where Hawkins started.
Right.
She is a Black woman who began working at the FedEx facility in Reno, Nevada, back in December 2018. Her role was a maintenance support rep.
And she had been in that position for years before the inciting incidents began. Those inciting incidents form the foundation of her Title VII Civil Rights Act complaint. According to the court documents, Hawkins alleged that during a specific window between May and July of 2024, two of her coworkers, identified in the filings as Mike Madden and Connie Lopez, began making comments of severe racial animus.
Wow.
Yeah. The documents specifically note comments targeting her African-American facial features.
Which is just appalling on a human level.
Absolutely.
But from a legal perspective, she recognized that this wasn't just a rude comment. It was a violation of her civil rights.
Exactly. The harassment allegedly worsened over those months, creating what the law formally defines as a hostile work environment.
Now, if you're listening to this and you find yourself in that situation, the standard playbook is to hire an employment lawyer to draft a formal complaint. You want a professional shielding you, right?
Oh, 100%.
But Hawkins litigated this pro se, meaning she represented herself.
Choosing to go pro se against a corporate entity of this size is a monumental decision. The statistics on pro se success rates in federal civil litigation are, well, they're incredibly bleak.
I always think of going pro se against a multinational corporation like FedEx as showing up to play in the Super Bowl completely alone.
That's a great way to put it.
You have no helmet, you have no playbook, and you're staring down an entire defensive line of high-priced corporate lawyers whose sole job is to crush you before the first quarter even ends.
That analogy captures the resource disparity perfectly. I mean, you're up against defense teams that have limitless resources and spend their entire careers looking for the tiniest procedural loopholes.
Right, like if you format a pleading wrong.
Or cite the wrong statute, yeah. They will file a motion to dismiss and have your case thrown out on a technicality before a judge ever even looks at the actual facts of the harassment.
But the filings show Hawkins didn't back down. She didn't stay quiet. She reported these racial comments to her direct manager, Adelzo Diaz.
And when the situation didn't improve, she pushed harder. By November 2024, she had taken her concerns straight to HR and a senior manager.
She essentially forced the company to put it on the record.
Exactly. She engaged in what the law calls protected activity. And this is the pivot point in so many employment cases. The initial discrimination is the spark, but the retaliation for reporting it is often the explosion.
So she blows the whistle.
Huh?
And this takes us to the first major roadblock in the federal court fortress.
The initial screening.
Yeah. After filing her lawsuit, the case goes through this screening process. Magistrate Judge Carla L. Baldwin reviewed Hawkins' initial filings and actually issued a recommendation to dismiss the retaliation claim entirely.
Which is huge. For a pro se plaintiff, receiving a magistrate's recommendation for dismissal is usually the end of the road. It's incredibly difficult to overcome.
Why did the magistrate recommend tossing it?
The magistrate's reasoning came down to a strict mechanical reading of the timeline Hawkins presented in her complaint. To establish a retaliation claim under Title VII, a plaintiff must prove a causal link.
A causal link.
Yeah, you have to show that you engaged in a protected activity like complaining to HR about racism and then suffered an adverse employment action because of that specific complaint.
Okay, wait. I was looking at the timeline the magistrate relied on, and it didn't make any sense to me. The magistrate noted that the adverse action Hawkins was complaining about was a demotion that occurred in March 2023.
Right.
But Hawkins didn't make her complaints to HR until November 2024. The timeline is completely backward. How could a demotion in 2023 possibly be retaliation for a complaint made a year and a half later?
It can't. And that is the exact logical trap the magistrate caught the case in. If you apply a rigid, literal reading to the way the initial pro se complaint was structured, the punishment happened before the crime.
Therefore, no causal link.
Exactly. Therefore, the retaliation claim is legally invalid.
But that implies Hawkins was arguing something entirely illogical. It feels like a symptom of someone trying to tell their entire traumatic story at once, without a lawyer there, to neatly separate the chronologies into distinct legal buckets.
That is the defining struggle of pro se litigation. A layperson writes a narrative. A lawyer writes a structured legal argument.
Right.
And this is where the mechanics of the federal judiciary actually functioned exactly as they should for an unrepresented citizen.
Mm-hmm.
U.S. District Judge Miranda M. stepped in to review the magistrate's recommendation in October 2025, and she completely reversed it.
Which is amazing.
Hmm.
But how does a district judge just toss out a magistrate's recommendation on a timeline issue like that?
Judge Dew applied a crucial legal mechanism required when dealing with unrepresented plaintiffs. It's called the more forgiving liberal standard of review.
Okay.
The courts recognize the inherent disadvantage of pro se litigants. So binding precedent dictates that judges cannot punish a plaintiff simply for failing to use the magic legal phrases or, for jumbling their chronologies, as long as the underlying facts allege a valid claim.
That makes so much sense.
Yeah. The judge has a duty to read between the lines, to look at the substance of the story, and to construe the pleadings in the light most favorable to the plaintiff.
So Judge Dew essentially translates the raw narrative into a formal legal framework.
Exactly.
She reads the story and realizes the actual retaliation Hawkins is claiming wasn't that old 2023 demotion at all.
Precisely. Judge Dew looked past the structural messiness and saw that the real retaliatory acts were a series of highly specific, devastating actions taken between November 2024 and August 2025.
The exact window immediately following her escalation to HR.
Yes.
And the retaliatory actions Hawkins documented are fascinating because they're so insidious. If you aren't paying close attention, they look like standard routine management decisions.
Right, but Hawkins kept meticulous receipts.
She really did. For instance, she documented that just days after she reported the discrimination to the senior manager, her supervisor suddenly changed her schedule. This wasn't just a minor inconvenience. It completely disrupted her ability to maintain her second source of outside income.
That is a targeted economic hit. It forces the employee to choose between keeping their primary job or maintaining their financial stability.
Then, in January 2025, right after the HR escalation manager, Diaz, revoked a schedule accommodation Hawkins previously had approved for her school classes.
Another massive disruption, this time targeting her future earning potential and educational advancement.
And it gets worse. That same month, she was actively excluded from monthly safety messages and red alerts that were directly related to her department.
That's wild.
Think about that. She's a maintenance support rep.
Right.
They're deliberately keeping her out of the loop on safety protocols in a maintenance environment.
Which borders on reckless endangerment.
Totally.
But from a strict legal defense perspective, you can see how corporate counsel would attack this.
Oh, sure.
They would argue in court, Your Honor, nobody was fired. Nobody had their hourly pay rate reduced. A schedule change is a purely administrative function. It doesn't meet the threshold of an adverse employment action.
Which feels like a massive loophole. Like, if a company can make your life a living hell through administrative functions, they don't ever need to fire you. They can just squeeze you until you quit.
Exactly.
So how did Judge Du navigate that defense?
She relied on a massive Supreme Court precedent. Burlington Northern and Santa Fe Railway Company v. White.
Okay, I think I've heard of that one.
It's the landmark case that fundamentally redefined what constitutes retaliation under Title VII. Before Burlington Northern, courts often required an ultimate employment decision, like a firing or a demotion, to prove retaliation.
Right, the obvious stuff.
Yeah. But the Supreme Court recognized exactly what you just described. Employers can weaponize the bureaucracy to silence whistleblowers.
So what is the actual legal standard now? How do you prove an administrative change is illegal?
The Supreme Court ruled that retaliation encompasses any employer action that might have dissuaded a reasonable worker from making or supporting a charge of discrimination.
Wow, so it broadened the scope immensely.
Immensely. The court explicitly noted in that decision that changing an employee's work schedule, especially if it impacts a plaintiff's particular circumstances like childcare or education, absolutely qualifies as a materially adverse action.
Because if you know that complaining to HR means your boss is going to nuke your college schedule or destroy your second income, you're absolutely going to be dissuaded from speaking up.
Exactly. It is a brilliant application of the law.
So by applying that forgiving standard and connecting the facts to Burlington Northern, Judge Du saved the case.
She did. She ordered that the claims for disparate treatment, hostile work environment, and retaliation could all legally proceed.
Okay, so she survived the initial gauntlet, but surviving a motion to dismiss just wakes up the giant, right?
Oh, yeah. Now the gloves come off.
Now that the case was officially moving forward to discovery, FedEx had to respond formally. This brings us to the corporate defense playbook.
Let's look at the answer.
Right. We have the formal answer filed on December 22, 2025 by FedEx's outside counsel, Ogletree Deakins. And for context, this was filed just 3 weeks after Hawkins formally resigned from FedEx on December 1st, 2025.
And just so you know, Ogletree Deakins is one of the largest labor and employment law firms in the world. When a company brings them in, they are signaling a scorched earth defense.
Wow.
Yeah. An answer in federal court is the defendant's paragraph-by-paragraph response to the plaintiff's complaint. It sets the boundaries of what facts are in dispute.
And their boundary line is basically drawn at deny everything. I mean, the sheer volume of denials is staggering to read.
It's pretty standard, but still overwhelming.
They admitted she was an employee. They admitted her start date. They admitted she is black. And they admitted that an HR specialist named Dan Andres conducted a formal investigation into her claims.
They admit the undeniable administrative reality.
Right. But almost everything else, every nuance of the harassment, every implication of the schedule changes was flatly denied.
Yep.
But here is where I really want to dig into the strategy. Because amidst dozens of pages of repetitive defendant denies the allegations, they drop a very specific, curious admission. Yes, they randomly include that an internal audit found Hawkins was being compensated for a job promotion she didn't qualify for. Why drop that highly specific, seemingly unrelated breadcrumb into a blanket denial of racial discrimination?
That is the hallmark of high-level defense strategy. That is not a random breadcrumb. It is a highly calculated legal maneuver laying the groundwork for what are called affirmative defenses.
Okay, walk me through the mechanics of an affirmative defense. How is that different from just denying the claim?
A denial just says, we didn't do what you're accusing us of. An affirmative defense says, even if everything you are accusing us of is 100% true, there is an independent legal reason why you still cannot win this case or why your damages should be severely limited.
Oh, wow. And FedEx listed 17 separate affirmative defenses in this document.
17.
So they are building 17 different escape hatches just in case the denials don't hold up in front of a jury.
Exactly. And that breadcrumb about the audit, that sets up one of the most ruthless strategies in employment law, known as the after-acquired evidence doctrine.
I'm fascinated by this. How does an audit about a promotion qualification legally counter a claim about racial harassment?
Well, it doesn't counter the harassment, it counters the payout. The after-acquired evidence doctrine essentially argues, hypothetically, even if we did retaliate against you, we later discovered this separate evidence, like an audit showing you were overcompensated or lacked qualifications, that would have constituted legitimate non-discriminatory grounds to fire you anyway.
That is wild. So they're arguing that because they found a technical issue with her promotion, any financial damages she might win for the civil rights violation should be cut off from the moment they discovered the audit issue.
Yes, it is a pure risk mitigation tool to cap back pay and front pay damages. It limits their financial exposure.
Incredible.
And the other 16 defenses are equally strategic. For example, they invoke business necessity. This is their direct counter to the Burlington Northern retaliation claim regarding her schedule changes.
Let me guess. They argue they didn't change her schedule to punish her for going to HR. They changed it because the Reno facility had a shift in maintenance demands, and they simply needed coverage.
It wasn't personal, it was just business operations.
Right.
To win on that, FedEx would try to produce algorithmic data or managerial testimonies showing the schedule shift was an objective operational requirement that had nothing to do with her protected activity.
They also claimed a failure to exhaust administrative remedies.
That's a classic procedural trap. Before you can sue in federal court under Title VII, you must first file a charge with the Equal Employment Opportunity Commission, the EEOC, and get a right to sue letter.
Right.
FedEx is preserving the argument that Hawkins may have skipped a bureaucratic step or that the specific claims in her federal lawsuit don't perfectly match the claims she initially wrote on her EEOC form. If they don't match, the court can throw the new claims out.
Now, I want to pause here. We are breaking down the brutal mechanics of federal litigation. It is important to understand that we are analyzing standard legal maneuvers by corporate defendants.
We're looking at the chessboard.
Exactly. FedEx's official stance in this December document is that they maintained comprehensive anti-harassment policies, they acted entirely in good faith, and they investigated her claims promptly and thoroughly.
That neutrality is vital to understand the system. In the pleadings phase, both sides are legally required to construct their strongest possible narrative to survive to the next round.
The plaintiff is building a narrative of systemic targeted retaliation.
And the defendant is building a narrative of neutral, objective business operations and strict legal compliance.
But it is a chess match, where one side is playing with an army of grandmasters who have access to unlimited resources, internal audits, and decades of precedent. And the other side is Sierra Hawkins, playing completely alone, trying to format her pleadings correctly while losing her second income.
Which is precisely why the ultimate outcome of this case, that February 2026 settlement, is such a rare and remarkable achievement.
So bringing it all home for you, the listener. Why does a deep dive into the procedural history of a Title VII case in Nevada matter to your life?
It's a great question.
Because it is the ultimate proof of the unparalleled power of keeping meticulous contemporaneous records. Hawkins didn't just walk into federal court and offer a vague narrative about a toxic culture.
No, vague narratives get dismissed by magistrate judges on the first pass.
She had the exact timeline. She had the window of harassment May through July 2024.
She knew the exact date her schedule was changed relative to the date she emailed the senior manager.
She had the exact month, January 2025, that her school accommodation was suddenly revoked.
And she had the documentation showing her active exclusion from those critical red alert safety messages.
That precise chronological documentation is what saved her. It gave Judge Due the exact factual scaffolding needed to apply the Burlington Northern Standard and force the case forward.
It turned a grievance into an undeniable surviving legal claim that ultimately forced a multinational corporation to the settlement table.
It's a phenomenal demonstration of utilizing the law.
It really is. But, you know, it also leaves us with a critical, forward-looking question about the modern workplace.
What's that?
Well, we just discussed how Hawkins proved that a seemingly routine management decision like changing a shift schedule was actually a targeted, human-driven act of illegal retaliation.
Right. Her manager made a choice to punish her.
But as corporate infrastructure evolves, what happens when that human element is removed? we are seeing a massive rise in algorithmic scheduling and AI-driven management software.
Oh, wow. That is a terrifying thought.
If a schedule changes the mechanism for retaliation, how do you prove retaliatory intent when the company points to an opaque, proprietary AI algorithm and says the manager didn't change her schedule after she complained to HR? The algorithm automatically optimized the workforce based on predictive analytics. How does a lone employee, or even a seasoned attorney, prove that the software parameters weren't subtly tweaked to squeeze out whistleblowers under the guise of automated efficiency?
It basically takes the business necessity defense and wraps it in an impenetrable layer of code.
The fortress just got a digital moat.
It really makes you wonder how the law is going to have to adapt when the retaliation is automated. It's a brilliant point to end on. Keep your records, document the algorithms if you can, and always question the timing of the bureaucracy. Thanks for joining us on this deep dive. Keep asking questions, and we'll catch you next time.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.